Good evening, members of the committee and members of the public. I will now call the Property Standards Committee to order. As this meeting is being held virtually, I will go over some of the rules of procedure for the benefit of members and the viewing public. This meeting is being streamed live via the City of Brantford YouTube account. All members of the committee will be muted upon entering the meeting and throughout when they are not speaking in order to reduce background noise. All web cameras for committee members shall be turned on throughout the meeting. If a member needs to leave their seat, please leave the camera on so that we can recognize you are away. Staff will be requested to join the video meeting should they need to answer questions of members. Any member of committee participating shall indicate they wish to speak or ask questions by pressing the raised hand button on the participant list screen. Your hand will stay raised until you are called upon, and staff will lower your hand when you have been called on by the chair. Movers and seconders of motions shall be indicated by raising your hand on camera, and the chair will call out who the mover and seconder are. All members of committee participating via online video conference will vote by a physical show of hands. A recorded vote will be taken by the clerk. Appellants, agents, owners, and delegations are participating via Zoom or telephone accordingly. All persons wishing to speak to the items on the agenda were required to register by 9 a.m. All delegations received in written format have been provided to the members of the committee and will form part of the meeting record. An event of a connection or service interruption occurring that affects quorum of the committee, we may recess the meeting for up to 15 minutes to regain quorum. If quorum is not achieved, the meeting is adjourned. Madam Clerk, please call the roll.
Lee Reiner.
Present.
Damon Smith.
Present.
Tamara Capoli.
Present.
Brenda Hertog.
Present. Members of the committee, do any of you have declarations of conflicts of pecuniary interest to make on any of the items before the committee this evening? Seeing none, there are no presentations or registered delegates for the meeting. This is a regular meeting of the Property Standards Committee. Members of the committee will hear property standards appeals, then must render decisions on the orders issued. The committee has the authority to confirm, rescind, extend, amend, and/or modify a property standards order. As the hearing is open to the public, please note that the names of persons participating in the hearing will be recorded in the minutes, which is a public record. Our hearing is for property standards order number 30-20 for 59 Kennedy Street, Brantford, and I will call upon staff to provide details of the report on this matter.
Through the chair, Gary Anderson, manager of property standards and bylaws, City of Brantford. I just wanted to speak to the committee briefly regarding process for our staff and our officers for the record. That the property standards bylaw is enforced reactively to complaints as they're received by our office. And once they're investigated and inspected, we follow standard protocols throughout the province to bring about compliance, which ultimately will lead to the issuance of an order, which is before you for one of those matters this evening. And as Madam Chair, as you indicated, when an order is issued, an owner has the opportunity to appeal, which this particular owner has. And I will now defer to Officer Christian Teixeira, who is the investigating officer in this file, to relay all the facts of this matter on the city's behalf to the committee, Madam Chair.
Thank you, Gary. Through the chair to the committee, I'm just going to go through a little bit of a background on the property. Like Gary had said, the property standards bylaw is primarily enforced on a reactive basis to complaints as they are received by the bylaw enforcement division of the building department. In this particular case, a complaint was received on February 7th, 2020 regarding mold and broken windows at 59 Kennedy Street, Brantford, Ontario. A preliminary inspection was conducted on February 10th, 2020 by myself, Christian Teixeira, to the property known municipally as 59 Kennedy Street, Brantford. The property confirmed a number of property standards bylaw violations to exist, which included mold found throughout the property, notably behind kitchen cabinetry and basement rooms and ceilings. Significant mold present would therefore require an air quality assessment test to ensure that the air quality is at a safe level for habitual living. Further that, we confirmed violations which included the ceiling in the basement having quite large holes in it, large cracking to the drywall ceiling in the master bedroom, water damage through the entire property to the drywall walls and ceilings. Also notably in the kitchen, the electrical system was not working correctly as a majority of the lights tended to flicker when turned on. Several of the hydro outlets seemed to short out or spark when something was plugged into them. Generally, an electrical safety authority certificate would be required to ensure the electrical systems are in a safe and working order, so that is what we asked for. Lastly, the window in the living room had been broken, had a large crack throughout it, and the fencing around the property was quite deteriorated and missing portions, or portions were left on the ground at the time of the inspection. Department records indicated that a previously issued property standards order number 131-17 remained outstanding. Accordingly, it was the decision of the bylaw division of the building department to proceed directly to the issuance of an order. The property standards order contained all the violations I had just noted to you. A request was made to the city's legal and real estate department that was returned on February 11th, 2020, that showed the subject property known municipally as 59 Kennedy Street, Brantford, to be owned by Titiola Feota of York, Ontario. The previously issued order relates to a severed portion of the property now known as 57 Kennedy Street, Brantford. Accordingly, property standards order number 30-20 was issued February 13th, 2020, detailing all the noted violations. A notice of appeal was received prior to the deadline, which we received that on March 4th, 2020. The owner is advising to us that they have a desire to demolish the building once they can claim clear tenancy on the property. I'm going to mute unless you have any further questions for me.
Thank you. Are there any questions for staff at this time? Mr. Smith? You have to unmute yourself, Damon. Thank you.
Through you, Madam Chair, to Christian. Have you worked with the tenant, worked with the owner to comply entry into the property so that they can try to fix this? And if so, what can arise from that?
The owner has been in contact with me throughout the time on the file. I know she's had her own struggles with the tenant, which is causing her some issues to comply with what we're asking. The tenant has always been quite pleasant with me, but he has also been quite hard to get a hold of. But we haven't arranged any formal dates where I can attend with the owner to help assist with the resolving of these issues.
Mrs. Capoli, did you have a question?
Hi, thank you, Chair. Christian, sorry, the previous order, the one that's still remaining outstanding, it seems familiar to me. Was it something to do with a shed or a fence along that property, or is this, sorry, I'm confusing something else?
The previous order was dated back in 2017, and it was regarding a retaining wall on the property that was in quite severe condition. We're still dealing with that matter.
That hasn't been resolved either?
Not to date.
Okay.
Any further questions for staff at this time? Okay, I will now call upon the appellant to address the committee. Hi, good evening. Could you please state your name and address for the record, please?
Can you guys see me? Oh, yeah. Hi, my name is Titi Fayada.
And your address, ma'am?
West Side Avenue, Toronto.
And sir, if you could state your name and address for the record, please?
Tolu Fayada, 106 Holland Vista Street in Holland Landing.
And what is it that you're asking the committee for this evening?
We're asking for the order to be rescinded for a variety of reasons, as I've outlined. And I guess I can go through each one if needed. So can I go ahead? Or-
Sure, go ahead.
Okay, I think the first piece was really to address the previous order. I know that Christian had mentioned concerning the retaining wall. First, I wanted to mention that this, of course, is a separate issue. The retaining wall, I did provide information and updates to the city for consideration, because our argument back was because we did get an engineer and a surveyor on that property, that it wasn't a sole responsibility of ours to address that retaining wall, and we wanted some assistance on that. We have already been fined and received that, and we've also incurred that expense to do the survey. Of course, the survey is part of the work that we do intend to do to that property, which has of course incurred many delays with the city, but we've been addressing all of them, and I think we're at the tail end now, as documented by at least a copy of the email. Our permits are ready, if we can get the tenant out. So either way, that retaining wall will be addressed, but the main order itself in terms of who should have fixed that retaining wall hasn't necessarily been addressed, because I provided my response to the city in that regard. I just haven't heard back. So I know it's still ongoing. So I don't want that to reflect on this particular order. I wanted to state that piece. And then the other issue is regard to the current order with regard to the house itself. Now, we haven't been in that house since last summer when he rented the house. We provided him with 2 weeks notice, free access to the house to do whatever he needed to before we rented it, because we had rented it to a previous tenant, a business owner who used it for his business. We never had any complaints or any of these damages. The first time actually seeing the damages that are being provided in the pictures.
Me too.
It's actually astounding to me. I don't know the extent of it. It's the first time I'm seeing it. Every time, and he actually never had an issue until it came to when he had to pay his rent. When his rent stopped being paid last September, which was maybe 2 months after he moved in August, was when the complaints started about the problems. He never allowed us to come in to take a look at the problems that he had complained about. We never had the opportunity to fix any. Of course, we couldn't get in. We had to deal with the constant threats. Every time we went on the property, we were threatened, so we're not able to go. When we finally, of course, then COVID hit and all of this happened and all the pause happened, we did submit our appeal to the order that came in. And ever since then, any attempts to come in has been met with a police threat to call the police. We can't come on the property. We can't do anything. We went there to try and attempt to remove some of the fencing just recently this summer. And he did indeed call the police and we're asked to leave the property. So, that's the one argument there. The other part, of course, is the fact that we weren't even given the ability to respond before we got the order. Granted, there was a previous order, but this was a completely new issue. We didn't have the opportunity to respond, to provide an update as to what's happening and why we cannot actually fix the problems that are happening. Tolu, I don't know if you wanted to add anything to that.
And my concern is that if we cannot get access to the property because of the threats of police action, and we have not seen the damages, then how can we fix an issue? So I think that we have to be given the chance to respond to any order given. And if the tenant is not being cooperative with us, in that case, then we don't have any recourse. We don't have that access. So I think, and that's my concern, is that from the tenants, from your side, you heard tenants' complaints, but we never given the chance to address that, to see why we could not respond to those complaints. And as City said, that's the first time seeing those pictures with damages. And I was quite surprised to see that damage because we never knew that was the extent of the damage. Because when the house was rented, that wasn't there. So that's the issue that we're having as well. It's the lack of access to the property with the police, threat of police action since last year.
Okay. Okay, I will now ask the committee if there are any questions for either of the appellants.
And sorry, just to add, I'm sorry, one more thing. I went there a couple of months ago, and he was in the house, and I was knocking just to see if we can talk to him, and no response. I wanted to just say, let's have a discussion so that at least I can address issues. I knocked and I knocked and I knocked. He was in the house with the dog, and no response. I had to leave. So, and the locks were changed, so we don't even have access to get in to do anything. So that's on my part. We've tried everything we could.
Okay, thank you. Mr. Reiner, did you have a question?
Yes, through you, Madam Chair. Landlords, property owners, they have some rights with regards to going into properties and doing work and things like that. My question is, has the appellant spoken with the police about attending with them to gain access to the property?
Yes, we did speak to the police. So the police did indicate it's not their jurisdiction. We have to go to the Landlord Tenant Act or board to address that situation. So I have filed two requests, one to the Landlord Tenant Board for non-payment of rent earlier on because he was supposed to be out. Our original agreement was for him to be vacated the property by March, regardless of whether he paid rent or not. He needed to be out by March so that we can demolish the house and proceed. That was on our original agreement. And that's what he clearly understood that. Here we are. But the police did say no, they couldn't do anything in that regard. It had to do with the Landlord Tenant Act. So we did file, and we did have a hearing date, but of course COVID hit, so that's been postponed. I have since filed a second one, noting the new complaints about health and safety for an emergency act to remove him from the property. If it's not safe, then he shouldn't be in there. And then allow us the access to be able to fix it, because even if he's in there, we can't fix it. He needs to be out to be able to do that amount of work, because obviously we want to tear it down, but any work that we need to do is significant regardless. So I since filed a second order, and a second request to the tribunal with an additional fee, and I still haven't heard back. And that was supposed to be the emergency one where, for health and safety reasons, you're supposed to get out. They did do their initial review. They did agree it's valid. Now I'm just waiting for that hearing to happen.
Mr. Smith, did you have a question?
Yes, Madam Chair, through you to our respondent. Have you tried talking with Christian? He seems to have a working rapport with us to go in there with him. And if so, what was the result?
I did ask at the time of the order to see what assistance the city can provide, but I think their hands may be tied. I'm not sure it's within their bailiwicks to do that. I did ask what assistance, and I know he mentioned the same thing he already mentioned before in terms of, they're reactive, they can only address complaints, but they can't necessarily do much more.
Knowing that, we do work with landlords that are facing something of this nature, and we do have some sympathy for that. It's just a question of, if you work with him, it shows in the eyes of the court and laws that would protect you from someone saying otherwise. And this is something that maybe you didn't know.
Yeah, I know. Maybe Christian, you can maybe answer that. I know I just sent an email to you asking, what recourse do I have? So I don't know what else. If there are other opportunities, then sure. But.
Well, through the chair to the committee and to the appellant, we do have avenues we can take when we have issued a property standards order. We could actually work on the obstruction method if the tenant were not to allow the owner within the building now that we've asked for it. But to date, I haven't been asked to do so from yourself, TT. I'm not sure if you were aware, but it's something that we possibly could help assist you with.
Yeah, I wasn't aware of that because I just needed, assistance as to where do I go from there. So that was it. Yeah.
Are there any other questions for the appellants at this time? Follow up from staff?
Yes, Madam Chair, through you, Chair, to the committee. This is an all too common scenario that we deal with in our office with situations like this. As the committee is aware, you've heard this situation before where we have tenants who are being uncooperative. Officer Teixeira is right. There is legal action we can take against a tenant, but quite frankly, they would be lengthier than the landlord tenant board application for removal or eviction. The owners who are present before you have indicated desire to demolish the property. I am aware that there has been there's a number of documents and processes required for demolition. Site alteration is one thing that's required, which has been pursued, as has site plan control. But to date, we do not have a demolition permit application. We likely won't until we have vacancy, because then we're going to require sign-offs from all the utilities. So that's what we're waiting for. The difficulty we have is we have a property both externally from a previous order and interior wise now that's in quite severe violation of the property standards bylaw. We need some closure. So Ms. Fayota is correct in that COVID came along at a bad time, and as I'm sure Madam Chair is aware as well, that a number of hearings have been delayed. But we just need some confirmation that that process will move forward. And once the tenant has been vacated from the property, that the demolition permit application can be proceeded with. Obviously, it's not our position to ensure repairs of a property that's about to be demolished, but we just need those processes finalized. Our position right now is that the order be confirmed. However, we are certainly amenable to a gracious time period to ensure that the tenant is removed and the demolition permit application is completed. That's the position of the city, Madam Chair.
Thank you. I will now entertain a motion dealing with this order. Mr. Smith?
Chair, just one question to through you to Gary. Reasonable timelines, assuming everything goes well, would that be anywhere between 3 and 6 months?
Through you, Madam Chair, we are being advised of hearings moving forward in October for the board and November. So I would suggest a 3 to 6 month time period would be reasonable in this particular case. The latter might be the better with 6 months to ensure that that process is completed and having the tenant vacated at that time, and then demolition permit application process completed with that moving forward. So yes, that's a very accurate time frame that you projected there, member, through you, Madam Chair.
Okay, we're looking in February then, I presume. Yeah. Not having a copy in front of me, I don't have the number for the file so that I can quote for a recommendation.
It's Property Standards Order 30-20.
I can make a motion
Okay.
that the appeal filed by TD Fayota, owner of 59 Kennedy Street, regarding Property Standards Order 30-20 be allowed and that this order be confirmed and upheld. And then an extension granted to February, what was I looking at? February 26th? Is that the Friday? Hang on. February 26th, 2021.
Do we have a seconder?
I'll second that.
Is there any discussion required on the motion? I'm sorry?
The Fiotas want to speak.
Hi, Mr. Fiota. There is a motion on the floor, so you won't be required to speak any further. Okay. I will ask the clerk to call the vote.
So the motion before you is to give an extension of 6 months until February 26, 2021. All those in favor, please raise their hand and leave it raised until your name is called. Brenda Hertog, Tamara Capoli, Lee Reiner, Damon Smith. So the extension of 6 months has carried unanimously on recorded vote.
Thank you. The committee's decision has been made on your appeal with the extension, as the clerk noted, to February the 26th, 2021. You will receive official notification of this decision from the building department. And if you wish to appeal the decision, you may do so to the Superior Court, and instructions will be provided with the notification you receive from the building department. And I'm required to advise you that as the committee did not quash the order, there is an additional administrative fee of $125. Thank you very much. Mr. Anderson, are there any updates for the committee? Oh. Sorry, before we do that, can I have a mover to approve the minutes from the Property Standards Committee held on July 16th, 2020? Second. Mr. Smith and Mr. Reiner. Now, Mr. Anderson, if you have any updates for the committee?
Thank you, Madam Chair. Through the committee, just a couple of updates specifically from the last meeting that we had, which was obviously a pretty long one. I just wanted to update in a couple of those items. The building at 293, 295 Greenwich, which we had upper and lower issues, are moving towards compliance. 34 Cayuga Street, which was item number 4.5 on the agenda, we have received compliance.
Excuse me, Mr. Anderson. Sorry to interrupt. Sorry, that's my fault. There was a motion on the floor with respect to the minutes. All those in favor? Opposed? Carried. Sorry about that, Mr. Anderson. My apologies.
No worries, my apologies as well. I wasn't unmuted, so it's just whether that you didn't have to hear twice. Through you, Madam Chair, to the committee, just an update specifically regarding the last hearing that we had, which was a rather lengthy one. I wanted to update you on a couple of the files from that hearing. 293-295 Greenwich Street, as you recall, was a property that was duplexed. We had issues with upper and lower there, moving towards compliance. 34 Cayuga Street was given an extension of time until August the 13th, and I can advise the committee that compliance was met by that due date by that owner, Mr. Venemus. So we do have compliance with that particular property. Another item on the agenda was for 88 Burkett Lane, which, as you recall, was an older barn type structure that was quite dilapidated. There's been an issue with some land claim rights to that property that has put a bit of a legal pickle for the owner as far as gaining proper legal authority to comply with the order. So that's being worked through a number of legal channels to gain compliance on that particular matter. And the last matter on that agenda was extended to October 19th, which of course is not here yet. So I just want to give you an update on those couple of matters. There are no pending appeals right now. We are at full complement minus one officer right now on staff with our department. We have a student leaving at the end of prior to Labor Day weekend. And at the EOC meeting this morning, I was given approval to extend 2 officers for COVID enforcement through the end of October. So from a staff complement perspective, we're pretty good. But that's just a brief update I wanted to give the committee this evening. Thank you, Madam Chair.
Thank you. I believe there's an update from the clerk's department.
Hi, Julia Sippel, through the chair to the committee. I just wanted to provide a quick update in regards to the formats in which we're holding these meetings. So last night, council did approve to continue with a virtual format through to the end of December 2020. In-person hearings will not start back up until such time as we're looking at options for the new year. But just be prepared that this is the format which we will maintain for the next few months as well.
Okay, thank you. We are now adjourned. Thank you, everyone.